going to be later.
Are there any other votes? Announce the results.
Ayes 89, noes 5.
The bill is passed. Mr. Morelli?
Yes, thank you, Mr. Speaker. Let me do a couple of things. First is to alert members of the Tourism Committee that will be convening that meeting in the Speaker's conference room. Ms. Markey is on her way for members of the Tourism Committee in the Speaker's conference room.
Tourism Committee in the Speaker's conference room.
And if I might, Mr. Speaker, if I could now, we're going to take a couple of bills off the debate list in the following order. Let me give them to you so we can proceed. The first that I'd like to take up is calendar number 440 on page 30 by Mr. Dendecker. And I'd like to follow that with calendar number 211 on page 12 by Mr. Bronson.
Clerk will read.
Assembly 4106, calendar 440. Mr. Dendecker, an act to amend the Vehicle and Traffic Law.
Explanation has been requested.
Thank you, Mr. Speaker. This bill will require the inspection of the tint on windows at the time of the annual state inspection.
Mr. McKevitt? Will the sponsor yield?
Yes, I will, Mr. Speaker.
Sponsor yields.
So just getting to the background, currently the law is already quite specific on, I guess, how dark the tinting may be on a windshield. If I'm correct, it has to allow, I think, for approximately 70% of transparency of light to go through the windshield. If I'm correct, that's the current standard under the Vehicle and Traffic Law?
That's correct. We're specifically not talking about the windshield factor, more on the windows on the side. And the law is currently 28%. Of a light transmittance.
Correct. And so from a perspective of the bill is if there are people who are in violation of this, unless a police officer specifically, pulls you over, and again, how a police officer is able to determine that on the spot, I'm really not quite sure. So it's your position that the person who's in the best instance to be able to determine whether that tinting is a violation would be at the annual inspection, which a car currently is required to go through according to the VTL.
That is absolutely correct, Mr. McCaffrey.
Right. And as a matter of fact, we've actually had this bill beforehand, and we've actually passed it on a previous occasion. And the governor vetoed at that time, I think under his perspective, that this would be an additional burden upon the inspection for the numerous punch list items, and that if this would not be increasing the cost for the inspection, this, I suppose, would create some sort of burden on the inspection stations. I'm just wondering whether you comment whether it's really an additional burden for them to go and try to, examine this during the conduct of the annual car inspection.
Yes, we spoke with many of them. We've tried to reach several different compromises. The agenda seems to be that the inspection stations feel that they're not compensated adequately currently, and this would be an additional burden to them, as you had mentioned. However, what I would propose, and I've said to them, is most of the vehicles that are going to be coming into their areas for an inspection don't have these windows that are even questionable. So at the time as the vehicle's pulling in, it's quite obviously there's no tint on the window, so there's going to be no extra burden to them whatsoever. Where there will be questionable problems is if a vehicle pulls in and it's a dark tinted window on the sides and they're not sure if it's legal or not, that they would be required to do some sort of extra work, and I think it's minimal.
And only because I'm not familiar with this, but can you inform us as to exactly what has to occur for that inspection? Does it require special equipment, or is it a lengthy process? How are they able to determine that the transparency through the tinting or non-tinting is within the applicable law?
There is a item that they can buy. It's approximately $200, and they hold it up to the window, and it will tell you if the tint on the window is within that category. It will give you the actual number. So if it was lower than 28, if it was 27, 26, 25, for example, that would be an issue.
And approximately how long a period of time does it take to conduct that test?
It takes about 5 seconds.
Okay. And again, I think from your perspective is, I mean, currently under the inspection program under state law, there's approximately 23 items which must be currently addressed during the inspection. And it includes very common sense things, for example, the brakes, the pads, making sure the hydraulic powers, shock absorbers, the headlights. So these are all basic common sense items which already currently are required under the law for that to be done, correct?
Correct, and I would also agree that many of them are done by means of a visual inspection, which is, again, I would say the majority of the vehicles, an overwhelming majority of the vehicles, upon visual inspection will not require anything else for the inspection station to do. However, when we do have windows that are too dark and are illegally tinted, it does cause traffic safety issues. So if you're approaching a four-way stop sign, for example, and you're looking to the other driver to make eye contact, to see that he's acknowledged that you are going to proceed, you need to have that eye contact available. Same when you're going in and out of a driveway, you want to see the other driver. And then from another standpoint, it's also, I believe, safer for law enforcement to be able to approach a vehicle and be able to see inside of it, rather than walk up to a vehicle that they cannot see inside, not know what activity may be taking place, and may actually be putting themselves in danger.
Correct. Actually, one interesting point, previously I know the auto dealers had some opposition to this bill at one point, but as my understanding, they've actually removed their opposition from this bill. Is that correct?
I believe we've tried our best to reach agreements with as many people as possible to explain how we believe that this will be minimally invasive to their business and give a huge reward for safety of our roadways as well as safety of our law enforcement personnel.
And it's my understanding that because of the need to be in compliance with those in law enforcement, I believe the auto dealers have removed their prior objection to this bill for exactly that reason.
It may very well may be. I believe we have the support of almost every police organization within the state of New York right now.
Now, if a car goes and it fails under the test of having the correct transparency, what is the remedy? Is the only remedy then that the car then fails inspection and cannot pass inspection unless that is remedied?
Well, the remedy would be to either remove the tint or make it be in compliance with current state law. Some of the tint that is put on windows is a tint that's actually like a painted-on tint. Others are a plastic film. The plastic film is sold at a lot of these auto parts stores right now, and what some motorists will do that like to have really dark windows is they'll put 2 or 3 layers of that tint on top, so we'll make it so dark that will not be in compliance with law and also prevent anyone from seeing inside their vehicle.
Right, but from the service station's perspective, they're not required to do that work. They could just simply say, hey, you fail inspection, and you have to come back again until that is rectified.
That's correct. And of course, many of the service stations, because I was in this industry at one time, if you were to pull up hypothetically and you had a broken windshield or broken headlights, and you said, I want to get an inspection, usually the mechanic will come out and say, if you don't fix the headlight or you don't fix the windshield, it's a waste for me to start the inspection process because you're not going to pass. Right. And I think the same thing will happen. A vehicle is going to pull up. They're going to obviously see how dark the windows are and say to that operator, your car is not going to pass inspection. I can tell by looking at the windows. If you don't correct that, it's not going to pass.
And I suppose one thing which is different of this proposed standard compared to the other standards, most of the other standards usually have to deal with wear and tear to the car. Again, you don't realize you think the brakes are okay, but they're not really okay. Again, you may have a broken light that you're not aware of, but in order to be in violation of the tinting, the customer, the operator of the car, had to do this affirmatively. It just doesn't happen by itself.
No, I would disagree with that statement. I think many of our residents in the state of New York are buying vehicles on the used car market, right. Are not aware that when they get the vehicle, what the legality is, how exactly dark it should be. Is it too dark? It looks okay to me. And they purchase the vehicle, they like the way it looks, and then lo and behold, maybe one day they get pulled over by a police officer that has one of these meters and is going to be issued a citation, and they had no idea they were not in compliance. I would also say I believe we're going to save a great deal of interaction between the police department and members of the public that are getting pulled over in those situations, as well as we'll save our police departments the cost of purchasing these items ourselves, because in reality, if we are doing this in an annual inspection, within a year or two, it won't be an issue anymore, because there won't be any more illegally tinted windows in the state.
Okay, thank you.
Mr. Saladino?
Would the sponsor yield for a few questions?
Yes, of course.
Sponsor yields.
Thank you. Can you please tell us, you spoke to the issue of people buying a used car, and in that used car, the windows may already be tinted. Can you tell us how expensive it is to remove that tinting from the windows, if
Well,
done professionally?
It would depend, I would imagine, on the type of tinting that it had. Most probably, and again, I can't say in every case, but probably it would be the tint that was purchased. That's a film. It's a plastic film that is applied to the inside of the car. They can be scraped off with a razor blade. So is there a cost involved? The operator could probably do it themselves.
If it's the type that is the film type, and then there's the smoke glass type.
That's correct.
Can you speak to us about removing the tint in that scenario?
Well, the smoke type, which is applied professionally, most of the businesses that apply that smoke type know the law extremely well and know that it is against the law for them to apply it any darker than the current legal standard. So most of the smoke windows are in compliance unless it was a vehicle that might have had those windows tinted in another state and then was brought here where maybe they don't have that law and they're now going to register that vehicle here. And in that case, yes, there might be more of a cost because they would have to probably either buy new glass or go to a professional glazier to have it treated where it could be removed.
Well, you mentioned two of the scenarios, but obviously the third scenario applies, and I'm sure you realize that the third scenario is something that people have to deal with in this state as well, correct?
Yes, that's correct.
And that third scenario being companies that don't care about the law, individuals that don't care about the law, and they're just going to flagrantly tint the windows to what they want versus what they tell them, what we tell them by statute is the legal tint, correct?
That can also happen, yes, sir.
Okay, so if this bill was to pass into law, wouldn't it then put an undue expense on people who perhaps could only afford one car for their family, have purchased a car in their community, and we know in communities of poverty there are a larger number of cars with the tinted windows than otherwise. And for those folks who can only purchase that one car and they're dependent upon that car to take care of their family members, get the kids back and forth to their different schedules, drive mom and pop, grandma and grandpa to the doctor, aren't we putting an unusually high burden on them? Just another burden on top of all of the expensive maintenance in order to pass a car and make it safe for the road?
I would totally disagree with that statement. I think what we're doing is guaranteeing that family that by complying with the law, you're actually having a safer vehicle. By having windows that are darker than the legal limit, it's going to impair your vision. Not only at night when it's even darker and you're driving around with these dark windows, but it stops the ability for you to make the eye contact with the operator of another vehicle. So I would think that we would want those people to have the absolute safest vehicles they have. So to go with your argument, if I could only afford a car that had no headlights, would it then be, should I not get it inspected? Am I putting an undue burden by having an inspection that requires a car to have headlights? So we're just trying to assure people that the cars that they have are completely safe and legal to operate within the state, and it makes it safe for everybody that operates a vehicle, not just that particular owner.
Well, I can see the argument of how it makes it safer for law enforcement. We certainly don't want to impose greater dangers on law enforcement officers who would be approaching that vehicle and can't see perhaps weapons and different issues that may be inside the car. It makes perfect sense. But have we looked into just how expensive it is to maintain a car in this state so that it continues to meet inspection? Did you figure in a sense of what it already costs a person to maintain their car? Brakes, tires, and all of the many maintenance issues that must be done in order to pass inspection and keep that car safe.
Yes, I have taken that all into consideration, and I believe, again, that an overwhelming majority, probably in the 95 to 99 percentile of vehicles, will not be affected by this piece of legislation because their windows are not tinted any darker than the legal limit.
Are we
the
doing
pu-
anything to bring a punitive approach to those who would skirt the law or would flagrantly tint their windows darker than the law allows now?
There is a punitive damage. If you get pulled over by a police officer in Nassau County or Suffolk County or in the city or a state trooper, and they believe that window is too dark and they have the meter with them and they check it, they're going to give you a moving violation. So you're going to be penalized financially as well as having a record that you were not in compliance with state law.
Thank you for your answers.
Read the last section.
This act shall take effect January 1st.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 82, noes 26.
The bill is passed. Mr. Morelli.
Yes, Mr. Speaker, before we go to the next bill, if members of the Labor Committee should note that we're going to have a meeting in the Speaker's conference room. Ms. Titus is ready to take members of the Labor Committee for that in the Speaker's conference room.
Labor Committee, Speaker's Conference Room. Ms. Titus is on her way.
Assembly 5414, Calendar 211. Mr. Bronson, an act to amend the labor law and the general municipal law.
Mr. Bronson, an explanation is requested. We will respect Mr. Bronson's ability to speak by being quiet. Shh. Shh. Settle down. We got far too many people on this corner. It is not a meeting area. Gentlemen, ladies, get away from that corner, please. Take it inside. And we're almost ready, Mr. Bronson, if the rest of our colleagues will try and contain themselves. Shh. Proceed.
Thank you, Mr. Speaker, and thank you, my colleagues, for accommodating this debate. And this bill is really quite simple. What it says is if a contractor or a subcontractor has failed to fill their duties and responsibilities on a public works job, which is in part or wholly funded by the federal government, and they end up, through that failure, being on the federal debarment list of contractors, meaning they cannot bid on federal projects, then we here in New York State will recognize that debarment, and so long as they're on the federal list, they will be on the debarment list here in New York State.
Ms. Corwood,
Thank you, Mr. Speaker. Would the sponsor yield?
will you yield?
Yes, I will, Mr. Speaker.
Sponsor yields.
Thank you, Harry. Thank you very much. It's a very succinct explanation of it. The one question I have has to do with the list itself. As you said, right now that list is created at the federal level, and that list is dispersed to all the federal agencies because this has been a federal action. Does anything in your bill require that federal list to be made available to the state? My understanding is that the Davis-Bacon Act does not require the federal government to make that list available to the states.
It does not, but those lists are available. They're available through a state listing process as well as a New York City listing process. That procedure is already in place.
So they would go to the federal government to get that list, or they?
No, there's I can't remember. Bendex and another one. I think the Bendex is across the state and the other one is for New York City. But there are lists that are already generated. But municipalities, under the requirement that they evaluate who is the most responsible low bidder in the bidding process, they're already required to, first of all, any person bidding has to say they're on the list. And then that municipality, that county, the state of New York, they all evaluate that when they're determining a responsible low bidder in a bidding process.
Okay, but you're saying that they're depending on that contractor to self-report that they are on that list?
There is self-reporting. You can look at the list or you can go through the other commercially done list.
Okay. The commercial listing service that you're referencing, how timely are they relative to the federal list? Is it immediate or is there a lag time?
I would have to get back to you. I don't know the answer to that question.
Okay. Thank you, Mr. Bronson. On the bill, Mr. Speaker?
On the bill, Ms. Corwin.
My one concern with this bill has to do with the list. I'm afraid, or my concern here is because we don't have a direct link to the federal government, that when they create their list, there may be some inaccuracies or delays in that list being made available to the state level. I think because decisions on bidding are being considered based on being on this list, I think it's important that we make an accommodation to make sure we have the most accurate information. So I would recommend that we add that as additional language into this bill to make sure that we have that we're operating off an accurate list. Thank you, Mr. Speaker.
Thank you, Ms. Cohen. Mr. Goodell.
Thank you, Mr. Speaker. Would the sponsor yield?
Mr. Brunson, will you yield?
Yes, I will, Mr.
Sponsor
Speaker.
yields.
Thank you, Mr. Bronson. As I understand it, when the federal government disbarred somebody under the Davis-Bacon Act, they disbarred not only the bad actor, but any company that's affiliated with the bad actor. Is that correct?
That's correct.
And your bill would disbar not only anybody who has been disbarred by the federal government, which would also include those that were disbarred by the federal government because they were affiliates, but your bill takes it one step further, or this bill takes it one step further and disbars those who are affiliated with the affiliates that have been disbarred, correct?
The bill will only disbar subcontractors who are on the federal debarment list.
Well, I'm looking at the language of your bill, and doesn't your bill specifically disbar those who, quote, have a substantially owned affiliated entity of a disbarred entity?
It does, and let me share with you that we have a definition in the labor law that says who those folks are. Those folks have to have a showing of some control on the subsidiary or the affiliate, and those levels of control are as follows, and this is in the labor law. Number one, any subsidiary of a company in which the parent of the contractor or subcontractor owns more than 50% of the voting stock. That's one scenario. The second scenario is if one or a combination of the top 5 shareholders own a controlling interest in the other company. And then number 3, if there is some other indicia or evidence showing control over the other contractor, even though there's not identifiable documentation of ownership or an interest. The reason we have that set up in the labor law is because we recognize that there ought to be a level of control if an affiliate is going to be debarred with the bad actor itself. The second thing, and we talked about this last year, Mr. Goodell, if you'll recall, the second area where we have put in a safeguard, if you will, to make sure that we're only grabbing the folks who have been bad actors or have been associated in some way with the bad actor. And that is there's an appeal process in the bill as drafted. That appeal process would allow that contractor to come in and show that even though they're on the federal debarment list, that they actually are not operating under the control, and so that would allow them a way to get off from this list under the bill.
Well, let me see if I can understand this. So let's say we have a bad actor on the federal level, actor A. Under federal law, not only is A disbarred, but any affiliated entity of A, right?
Under the federal standards.
So that would be, let's say, for sake of discussion, companies B, C, and D. So now A through D are disbarred under federal law. Then this bill says that if you've been disbarred under federal law, which would be A through D, any affiliate of that entire group is also disbarred under New York law, right? So that means New York could disbar companies, whatever, EFG. So my question is, the federal disbarment, which relates to an affiliate, has similar standards, 50% or more ownership. That means under this bill, we could be disbarring companies that have very, very small ownership connection with the bad actor, company A in the example. Could be less than a controlling interest once you get down through it. So my question is, it's one thing to say we ban an affiliate, a controlled entity of a bad actor. But this takes it to the point where we're not only banning an affiliate of a bad actor, but we're banning the affiliates of the affiliates. And it could even go a third step, right? Presumably. Or a fourth step. Why aren't we limiting the disbarment to those companies that are disbarred under federal law, period?
Under current law, if you meet the standard of a substantially owned affiliate, then we could have a disbarment under that standard. If you just look at the federal level, they're already on a disbarred list. The reality is the federal government has made a determination that they're disbarred because of their affiliation, because of their bad acts, or a combination of both. Let me give you a scenario. If we don't do this, a New Jersey company, and New Jersey has a law similar to this one, a New Jersey company that's disbarred on the federal list is then disbarred or is then not allowed to bid on contracts in New Jersey, but they could come across and come to New York and bid here in New York State. This law would allow us to do the exact same thing that other states have done, and the reason is a good reason. The reason is if you have been shown that you're not following the wage requirements and other requirements that we have in place to protect workers and to make sure that there's a level playing field so that a bad actor who's taking advantage of the system and is violating the system, who then may be bidding with good actors, they're not doing this at a different playing field or business field, if you will. So there's a lot of good reasons to do this. I understand your question. I think you're overreading this. I think that the reality is if you're on the federal list, then there's a determination been made. We have a safeguard in the state law that we want to pass here that says if for some reason you think there's a problem that you're on that federal list because the affiliation is too tenuous, then you can make that case here in New York State. You have that appeal process. When you make that appeal process, if you're successful, you'll be not put on the barred list here in New York.
Thank you, Mr. Bronson, on your comments on the bill.
Thank you, Mr. Goodell.
On the bill, Mr. Goodell.
I applaud the sponsor's objective of disbarring anybody who's violated the Davis-Bacon Act and is on the federal disbarment list. They should not be doing work in New York. I don't have a problem with that. I don't think anyone here has a problem with that. We need to be sensitive, though, that the federal disbarment includes not only the bad actor, but any affiliated companies controlled by the bad actor. So both groups of people are on the federal disbarment list. I don't have a problem with that. Most of us don't have a problem with that. The problem I have is that this bill takes it one more step and says that if you're an affiliate of a bad actor, you can be banned in New York. Think about that for a minute. Because our job is to make sure we get bad actors out of the system. That's our job. But our job is not to punish innocent investors or innocent businesses that don't have a controlling interest that ties back into a bad actor. And so when you talk about affiliates of an affiliate, you've gone beyond the bad actor. You've gone beyond any companies controlled by the bad actor, and now you're banning from New York State companies that only have a limited tangential interest, which might be just over 25%. So we want to encourage good actors. We want to encourage companies that do comply. We want to open up as much competition as we can in New York State to good companies, and we don't want to ban everybody that has any connection of any kind, no matter how remote. And unfortunately, this bill language goes too far by banning not only those who are on the federal list, banning not only the bad actors but affiliates, but banning affiliates of affiliates, and that takes it too far. because then we're banning innocent companies from doing work in New York State merely through a tangential, two-step removed ownership interest that goes back to a bad actor. That's too far, too removed, and it's going to result in higher costs for our municipalities in construction work and will hurt innocent companies that are good actors. We should make sure we don't hurt the good players at the same time we're banning the bad players. For that reason, I recommend a no vote. Thank you, Mr. Speaker.
Read the last section.
This act shall take effect on the 120th day.
Clerk will record the vote. Mr. Bronson to explain his vote.
Yes, Mr. Speaker. I think we should have some clarification on the record. There's a couple of things that we have an interplay here, and we have to be cognizant of it as we're considering our vote. First of all, this bill will only prevent bidding in New York State if the contractor, subcontractor, affiliate, sub-affiliate, if that company is on the federal list. If you are an affiliate, to get on the federal list, you have to meet a standard set by the federal government of substantial affiliation. At the federal level, these companies have an appeal process. It's a very robust appeal process. So they can appeal being on that list before we even consider whether or not we are going to have reciprocity with New York State. Then once they get here, if they're on the federal list, so they had to have met that first threshold, they meet that threshold, they have an opportunity to appeal that threshold, then we look at them and we say they're debarred here in New York State, and then we give them another opportunity to challenge the determination. In challenging that determination, one of the criterions that they could argue to the Department of Labor is the definition of our substantially owned affiliated entity. So there is no way that it's going to be this extreme, not really connected situation that has been suggested would be the case. There has to be a substantially owned affiliated entity judged at the federal level and again at the state level. I encourage with those safeguards voting in the affirmative. Thank you,
Mr. Bronson in the affirmative. So now we have a hint. Will they stay?